All right, thank you. I'm so excited that you guys are excited for CE. I try to be fun. So I'm going to be talking about buyer's agency today, buyer's representation. Are you excited about that? Yeah. All right. This was cracking me up when he was doing this because I got to thinking about a few things. In the wake of the lawsuits and the settlement, who is experiencing massive bleeding right now? NAR, National Association of Realtors. In fact, they took down their membership count from their website because it's dwindling very quickly. Airway, who in here is possibly choking a little bit about some of the changes that might be occurring with buyer's agency and commissions? What about respiration? Is anybody breathing faster or slower because you're wondering, how am I going to maneuver this? The circulation and hypothermia. How many of you are all hot and ready to go with buyer's agency? Anybody? Who's a little frozen in their tracks? Anybody? Yeah, a couple? All right. That really made me kind of laugh because I think we're in some of that same situation with the buyer's agency stuff. Now let's see if this works. I don't have my presentation. Is my presentation up, Allie? All right, the clicker's not working. All right, that's a bummer. I'm going to try this one more time here.
Stop the bleeding.
Stop the bleeding. Breathe. Yeah. I don't know where that leak is. It's somewhere in the... All right, so I'm going to have to do it manually.
I can do it for you. I stand here next to you.
No. You... All right. So what we're going to talk about briefly, this is going to be 2 hours. So because I am licensed by the LREC to be teaching continuing ed, please turn off your electronic devices and put your phones away. I need to follow the license law as well in case somebody shows up. You don't need your computer. I'm going to guarantee you, Keith Rye and I know 100% that none of your clients will die from a real estate transaction that you don't answer to for just a little while. Everybody will be okay. Is that right, Keith? Yes, everybody will be fine. So we're going to spend a little bit of time at the beginning of this talking about agency law in Louisiana. Agency law in Louisiana is a very interesting thing. It operates, get this, differently than any other place in the country that I'm aware of, right? So with agency law, we have a customer, right? Who's a customer? It's somebody that you don't have any working relationship with, right? I want you to remember that because we're going to come back to the customer relationship later on in the class. A client, right? A client is somebody that you've got a working relationship with, correct? All right? And we can operate as a designated agent or a dual agent. I also want to clarify that dual agency, by the term that is used in Louisiana, is a really bad term. Other states call it something like transaction brokerage, but dual agency implies that you're actually an agent for both parties, and you are not, okay? Once you enter into a dual agency capacity, you cannot advise or counsel one client over the other. That is not an agent, right? An agency relationship, you have what kind of duty? Anybody? Very good. All right, you pass. You have a fiduciary duty, all right? And that's the biggest key that I'm not 100% sure that clients really know what we do, how we do it, and a lot of the problems that we currently have with these lawsuits and the outcomes are our fault as an industry. 100% our fault as an industry. Okay, we're going to talk about that too. So as a buyer, you can have a designated agent, and a seller, you can have a designated agent. What's going to change with dual agency and designated agency with the new rules and everything? We don't know yet. I'm going to give you my suggestions and my opinions on what might be best practices, but that's all they are my suggestions. You have a broker or are the broker, and you get to come up with your own ideas. All right, I'm going to really be going through quite a bit of this stuff, the definitions and agency stuff pretty quickly. The material that you have in your books is actually the exact same material that I teach in my 4-hour buyer's agency class, but we go very deep into agency law and how this is going to work in the 4-hour class. So you're getting the condensed version. You can try to follow along in your books the best you can, but really I think you should pay attention mostly to what I'm talking about as opposed to being worried about what's in the book. So what's a customer? A customer is a person who is provided service by a real estate licensee but who is not a client of the real estate licensee because the licensee is only performing ministerial acts. In this case, the licensee is not acting as an agent. The actual services received from the licensee depend on the arrangement that is established between the customer and the licensee. How do we arrange an agreement with a customer? That's verbal, right? Okay? That's not going to necessarily be a written one. Here's some things that you can do with a customer. Respond to phone inquiries, conduct an open house, setting an appointment to view a property, responding to questions from persons walking into a licensee's office, accompanying an appraiser, inspector, contractor, or third party to visit a property, describing a property or the property's condition, completing business or factual information for a person represented by another licensee on an offer or contract to purchase. This one really caught my eye because I've had agents in the past say, well, I'm actually a seller's agent. I just filled out the contract for the buyer as a ministerial act. According to this, you can't do that. If you take a look at this, completing business or factual information for a person represented by another licensee on an offer or contract to purchase. So if you have been filling out an agreement, a contract for a buyer customer to present to your seller, you may have been violating this. This really kind of hit me as we're getting more attention drawn to this, because nowhere in the pamphlet that we're given by the LREC with the definitions does it say that you can fill out a contract for an unrepresented person. You ever thought about that? How many of you might have done that? Whoops. Right? Interesting thoughts. I would suggest we get a little more legal guidance on that, because this is kind of a new thought process to me, because it seemed to have been customary practice in some ways here, but I don't think it's actually within the law. So client. Some of my slides, I don't know, they got reformatted or something. I created this on Windows. It's running on a Mac, so I don't know what happened to some of them. But a client is actually somebody that you're working. Did you have a question? Do you have a question? Because I'm happy to answer. Yeah.
Oh, it said a person represented by a licensee, so you can't do it if they are represented by someone else.
No, if they're not.
Represented by another licensee.
Right.
Completing business or factual information for a person
Represented by another licensee. So if you have an unrepresented buyer and you are a seller's agent, but that buyer wants to make an offer, according to this, you should not be filling out that purchase agreement for them, because they're not represented. Does that make sense?
But if they are represented,
You can help out with filling out documents. Isn't that weird? Yeah, but how many times have we done stuff like that because the other agent just doesn't get their stuff done, right? Okay, so this I think we're going to want a little more clarification on, but I want you to think about it before going forward with some of the new changes, right? Because when we get to how we're going to handle buyer's agency and how seller's agency may or may not change, etc., and dual agency, whether it goes away, I don't know, right? I want you to keep that in mind because words matter. And how we operate is all about what the LREC gives us. And right now, that's what the LREC gives us. And nowhere in there does it say we can fill out a purchase agreement for somebody that is not represented by us. Mr. Lawyer, would you think filling out a purchase agreement for somebody that you don't represent would be a good practice? Probably not. Yeah. Okay? Food for thought. All right. Mrs. Lawyer. I'll go that direction. All right. So, becoming an agent in Louisiana is very easy to do. It's a very tricky step. And do you know when an agency relationship is formed, technically, between an agent and a client in Louisiana? Does anybody know that? Yeah, when the client thinks you are their agent. How handy is that, guys? Because if they want to sue you, oh, you were their agent. If you made them mad, you're their agent. But if they have to pay you, oh no, I didn't think they were my agent. Does that make sense? So operating without a buyer's rep agreement all this time has never been a good position for you to be in. When I moved here 7 years ago, I was shocked at how few people were using buyer's agency agreements, and I was teaching buyer's rep agreements 7 years ago because of how important they are. Now, y'all are going to kind of have to do that unless you're not a realtor. So, when does becoming a client or client agent occur? We discussed that. Must the relationship be in writing? Not currently. By Louisiana real estate law, no, that agreement does not need to be in writing. But you're also not guaranteed any payment. The real estate world, and I saw some people cheering me on in the back there earlier, the real estate world has become very complacent on handouts. Buyer's agents have been very complacent, looking for handouts. What's offered on the MLS? And then getting upset at the closing table if they don't get the same amount that the listing agent got. There's no rule that ever said that had to be. You guys now are going to be determining your own worth and setting your own fee. Right? Okay? Think about that as we go forward. What are the terms of that relationship? How many of you have listing agreements? The listings, they show what that relationship is, right? It tells you what your relationship is. If you don't have a buyer's rep agreement, what is that relationship? It's not defined. That's not good for anybody. Because you have not come to a meeting of the minds as to what you will do, what you won't do, how much you're worth. You know, it's funny, the last job I applied for, it's been a while, the person asked me, they said, well, what is your wage requirement? Why is it, how many of you have had a job? A job where you show up, clock in, clock out, whole things, you know, all right? What was one of the first things you asked when you got to that job? What am I being paid? Why is this any different? Why do we show up not knowing what we're going to be paid with a buyer? Why do we not have any, I guess, confidence in asking for that sometimes? That's because the industry has made us complacent with something being offered on the MLS. And then we get mad because we think that that listing agent should have negotiated more for us. because I work as hard as they do. All right? Things are changing. So agency means a relationship in which a real estate broker or licensee represents a client by the client's consent, whether expressed or implied, in an immovable property transaction. An agency relationship is formed when a real estate licensee works for a consumer in their best interest and represents them. Agency relationships can be formed with buyers, sellers, lessors, lessees. Client's best interests. Remember that too. We're going to talk about that when we get into buyer's agency best practices. Okay? Who determines the client's best interests? The client. Yeah. And how many times have I heard an agent say, that's not in my client's best interests? Did you ask them? All right? I'm going to encourage you to, do we have any ninjas? Ninjas. We got a couple of ninjas back there. Good. Anybody not know what a ninja is in the real estate world? All right? Ninja selling. I suggest you take a look at that. Larry Kendall, friend of mine, ninja selling came from Fort Collins, Colorado. That's where I came up in the real estate business. And so I grew up in the real estate. Oh, here's a ninja selling book. Look at that. All right, Larry Kendall. I came up in the real estate business with all the original ninjas. One of the things that they teach in ninja selling is to always remember that our role is to provide information and the client decides. Remember that. We provide, they decide. We provide, they decide. All right? Sometimes we get a little overzealous in our agency capacity and start making decisions for them. Sometimes they say to, right? But sometimes we start saying things and doing things that we may not have actually checked out with them and we assume are in their best interests. Keep that in mind when we talk a little bit later about how you're going to be compensated as a buyer's agent. Okay? Designated agency. An agency relationship that shall be presumed to exist when a licensee engaged in a real estate transaction is working with a client unless there's a written agreement providing a different relationship. What different written agreement relationship might you have? Anybody having a thought? Dual? Okay, that's one. There's going to be another one that I'm going to bring up to you. Yep. Consultant. Yep. Fee for service, right? Okay. There's going to be another type of relationship that is not agency. And it's going to come in handy, I believe, going forward. And that is a customer relationship. Okay? That doesn't have any agency fiduciary duty to it. But I'm going to talk about how that's going to come in handy down the road and what that may or may not mean for your compensation. Okay? The law presumes that the real estate licensee the client works with is their designated agent unless there is a written agreement otherwise. That's why you might want to have a customer agreement. Okay? No other licensees in the office work for them unless disclosed to and approved by the client. Why is that written in there? Because how many of you have been in the business 20 years or more? How many of you have been in the business 10 years or less? 5 years or less? All right. There was a day that all agents were seller's agents. And there was no buyer's agency. And if you had a buyer that you showed a home to, you became a seller's sub-agent. Yeah, I can see some confused looks on some of the newer agents. You know, they're like, what? Well, the consumers back in the 90s got fed up and they sued. And guess what was created? Designated agency. Well, now consumers have gotten fed up and they sued. And now we're coming up with some new rules. Here's some interesting facts that I learned How many of you were on the LAR town hall with Adorna Carroll a couple weeks ago? That was fabulous. Normally, I'm not a big Adorna fan. She can rub me the wrong way, but that one was actually really good. She said, "Nobody smells the leather in my car without a buyer's agency agreement." I loved that. But I learned a lot of things. You know, NAR has been sued many, many, many times. This is not a new occurrence. The previous lawsuit, the settlement that they had, actually, I believe that ended in either 17 or 18. And that's why in 2019, these lawsuits came up. The Department of Justice came back in, is because those settlements had sunset. This current settlement, does anybody know how long this current settlement is for once it's approved? 7 years. So don't assume that this is it, right? Just know that in another 7 years, the DOJ is going to be coming back around. The DOJ is already looking at the clear cooperation rule, and they're also looking at something else they're going to be digging into. So we're not done. Okay, designated agency duties. To obey all lawful requests to promote the client's best interests. Again, who determines the client's best interests? Them. To exercise reasonable skill and care. Okay, let's go back to reasonable skill and care and the number of years that you have been in the business. Who's been in the business less than a year? Anybody? All right. So those of you that have a license for less than a year, do you think that you should have the same expectation of reasonable skill and care that somebody with, I've got 26 years, how many years you got? 24? 27? Any more than 27 in here? All right, should you as a first year licensee be held to the same expectation of reasonable skill and care as those of us with a couple of decades? Yes or no? Yes. By the term that you have a license, you're expected to have the same reasonable skill and care. That's kind of a scary thing, right? That's why you're under a broker supervision for a while, is because you've got to have somebody coaching you through that kind of stuff, all right? Reasonable skill and care is going to be determined by who? A judge. I don't want that figured out on me. I don't want to ever be a test case, right? So always get good information. To keep information that could materially harm the client's negotiation position confidential. Oh my goodness. How many open houses and office meetings and things do I hear? Oh, well, my client has cancer and they really need to sell and they're going to move to blah, 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 blah. Shut the mouth. Oh, they really have to sell because they need to be over here. No, they don't really have to sell because, you know, they're doing this. Stop yourself. I hear this all the time. That is nobody else's business, not in the office, not anywhere. All right? Those people's motivations and what's going on in their life is nobody's business. All right? It's just like going to the doctor. If I knew that one of you has a doctor's appointment, oh, he's got a doctor's appointment. Do you want me to tell everybody why you have a doctor's appointment? No, right? We are the same, we should be the same professional that doctors are, that attorneys are, that CPAs are. But I would venture to say, and many times we are not. A lot of these rule changes are going to increase the level of professionalism that's going to be occurring in the industry. So the education just has to continue. Just keep getting after it. Present all offers in a timely manner. To seek a transaction at a price and terms acceptable to the client. To account for all money or property received from the client in a timely manner. It's funny where they say money or property, but I actually know of a broker back in Colorado that actually works for cows and different things like that. Because he likes to help out his clients, and he has that option because he's the broker. He's traded for boats and cars and cows and stuff like that. So if they give you a cow as a deposit, take care of it, okay? All right. Who are these guys? They're dueling. It's a different kind of duel, but I love these guys because I'm from Colorado. We target practice on those bad boys. I could take one out at 400 yards. All right, dual agency means an agency relationship in which a licensee is working with both buyer and seller or both landlord and tenant in the same transaction. However, such a relationship shall not constitute dual agency if the licensee is the seller of the property he owns or if the property is owned by a real estate business of which the licensee is the sole proprietor and agent. You cannot be a dual agent for yourself, right? Because you're only going to be representing yourself's best interests. A dual agency relationship, that's about the leases. I'm not going to get into that. Dual agency is allowed only when informed consent is presumed to have been given by any client who signed the dual agency disclosure prescribed by the Louisiana Real Estate Commission. So you're going to be in trouble if you have an undisclosed dual agency position, right? Correct? But agency is formed when somebody believes you're their agent. Yikes. Open houses. Think about open houses, guys and gals, and in between. When you do an open house, how many of you have your agency relationships disclosures with you at the open house if you're the listing agent? You should do that, right? Because how many times in an open house does a customer walk in and they start telling you certain things about themselves, and maybe they think, geez, you're really nice. I like this house. Will you write that up and be my agent? Maybe they don't even say, would you be my agent? They just say, I really like this house. Would you write that up? You have already created an undisclosed dual agency relationship at that point. Now, luckily, there has been some clarification from NAR as of yesterday about what's going to happen when showing at open houses. Because that's been some question. What's going to happen when an unrepresented buyer comes into an open house? Right? Because it has been said that we have to have some kind of written agreement in place with a buyer before we show them houses. Right? NAR has said that that will not apply to an open house. Okay? But in that same vein, you need to have some documents on hand because these clients need to be educated and they need to be informed about what's happening. Okay? So number one, be sure to have your agency disclosure pamphlet with you if you're the listing agent for sure, holding your own open house. If you're another agent holding that open for a listing agent, it's not as important, but it's still very important. Because we're going to talk a little bit about when does that disclosure need to be made? Do you all know technically when that disclosure needs to be made to somebody? Say it again, Keith. Face to face, close. Immediately, close. Technically, prior to any substantive contact. Substantive contact occurs whether you ask for it or not. And I'm way out of order on the way this class goes, but because of where we are today with buyer's agency, I'm really attacking this a little bit differently than normal today. Substantive contact can occur without you even wanting it. How many times does somebody walk up to you and they're talking about real estate to you, whether it's at an open house or a party or whatever, and they start telling you, yeah, you know, I really want to buy a house. I've got $50,000 down and my kids need to be in this school district, so I need to be. That's substantive contact, folks. And you need to kind of stop the conversation at that point and say, I need to get you a disclosure because you're telling me things that could be used against you in negotiations later, right? So really be cognizant of this going forward, guys. The other thing that's going to occur is, remember I mentioned at the beginning of this that NAR is losing members? Big time. Because in many other states, the membership requirement of the Association of Realtors is not in place for you to get to the MLS. So people are leaving the Association of Realtors in some cases, and they still have access to the MLS. That's not the way it is here in Louisiana. Personally, I think those two should be decoupled. Do I think that's coming to Louisiana? I think it very well could be soon. And I said that when I moved here 7 years ago. Guys, we are one lawsuit away from that being decoupled, 100%. Because your membership in an association should be separate from your subscription to a business service, okay? Now, I love associations, all right? I'm past president of North Shore Area Board of Realtors. I think that associations do great things for their local communities. I think that's how we bond and we hold each other together, and we serve our communities and have fundraisers and get to know each other and educate new leaders and things like that. Might that change? I think it might change. And the other thing is, though, if you leave the National Association of Realtors, you will no longer be covered by this settlement. So that's a quandary, isn't it? Yeah. Right? So I don't know how many brokerages that are leaving the National Association of Realtors are thinking about that and not being covered by this settlement, or if they're making arrangements outside of that to be covered, because there are ways for other firms and whatnot to be covered by that. They can buy into the coverage, thus replenishing some of the funds that NAR settled for, right? NAR settled for what, $418 million? I guess Home Services just settled, is that right? Any BHHS folks? Yeah, they just settled for $250 million. Yeah, so we're getting down there. We're getting down there. All right. So more definitions as we're working as an agent, right? I'm going to get through the dual agency thing. Confidential information. Confidential information means information obtained by a licensee from a client during the term of a brokerage agreement that was made confidential by written request or written instruction of the client, or is information the disclosure of which could materially harm the position of the client unless at any time any of the following occurs. So let's talk about this before we talk about the following. Is information obtained by a licensee from a client during the term of a brokerage agreement. What is the term of the brokerage agreement if you don't have something signed? Do you know when that agency relationship was formed? When they think you're their agent. You may not think it, or you might think it and they don't think it, right? That's the other importance of having a written agency agreement in place, always has been, right? And confidential information means information that may harm, materially harm the position of the client. Who decides if that information might materially harm their position? The client. Again, that's a reason for us not to be talking about things we learn about our client that we might think is innocuous and might have no bearing on what it is that they're doing. We don't get to decide that. Something we think is minor may actually put them in a worse negotiation position, right? All right, so the ones that would allow the confidential information to be shared is the client permits the disclosure by word or conduct, the disclosure is required by law or would reveal serious defect. The information becomes public from a source other than the licensee. That doesn't mean you get to share it secretly with somebody in your office and tell them to go tell it. All right, that's not the way that's going to go. It would have to come from another source, public records or the client. All right. Confidential information shall not be considered to be about the physical condition of the property. Confidential information can be disclosed by the designated agent to his or her broker for the purpose of seeking advice or assistance. That's always been the case, right? The broker should always have the knowledge that they need to help you through that transaction. That's why all of the listing agreements and your upcoming buyer's agency agreements are all going to be owned by the broker, all right? You as agents don't get to enter into a buyer's agency agreement separate from your broker, okay? That all has to be provided by the broker. How many brokers do we have in the room? All right, how many of you brokers have your buyer's agency agreement ready to go? How many pages is it? Hand in the back, way in the back. Miss, how many pages is your buyer's agency agreement?
Right now, without any guidance from our board and our agency,
1 page? Okay.
but it also accounts for ministerial acts.
It accounts for ministerial acts? Okay. I do believe that LAR is going to introduce legislation if they have not already. Last time I talked to Norman is that they were planning on introducing legislation requiring the use of a written agreement with the buyers. But I don't think that LREC is planning at this point to provide the form. Do you know, Sabrina? Well, right now, LAR is introducing legislation to require the written agreement, so it's not just NAR. There will also be state law to require a buyer's rep agreement. Is LREC planning on providing a form? I don't think they are. They are. Okay. So if LREC provides a form, it'll be interesting to see if it's a mandatory form, if it's a suggested form. They've got some both. It's going to be a suggested, is what you think? Okay. So as you can see, we're finding things out as we go, right? And yes?
When I spoke with Kim Calloway at LR, she said that they were going to release a suggested form that will
Yeah.
also kind of give everything that NAR needs to be in there, make sure that that verbiage is in there, and then once it's released, then each individual brokerage can kind of amend it so long as they keep the main things in there.
Cool. So there, she spoke with Kim Calloway, legal counsel at LAR, that they are going to release some kind of suggested form that will have certain clauses in there to make sure that we're covered appropriately for the NAR settlement. But of course, none of this has been approved yet, right? But we are probably going to see rules changes happen anyway, even ahead of the approval. The approval probably will come in November is what I'm kind of hearing right now. But the rules changes are going to be mid to late July, possibly the beginning of August. When we get to the second part of this class, we're going to talk about some of the recommended things that should go or could go into your buyer's agency agreement. I am not an attorney. I don't even play one on TV. So some of the things that you have in your packet are just sample language, okay? And that in my, I do have a disclaimer in that as well that I'm not an attorney. So anything that your brokerage puts together should be reviewed by an attorney, all right? And we're going to talk about what could, would, should be in the buyer's agency agreement, or at least a part of your buyer's agency your buyer's consultation. All right. Here is the best practice for the substantive contact. That's in that in your packet as well. Have the forms readily available at open houses when people come to see the home. Another thing you might want to have at your open house, or even in your with you, is some kind of Q&A that you come up with that may have some questions that clients have asked you or might ask you, so that you've got a little bit of arsenal with you, so that you can give it to them possibly, but at least have something to study about the questions and answers that you should have for these consumers. How many of you have talked to consumers about the changes yet? Do you find them to be confused? Grant, why are you shaking your head? They're not confused.
I think it depends on, I think you have to have a conversation with them, just make them understand basically everything you should be talking.
Okay.
And they understand that, but it just becomes.
Okay, so that's after explanation. Okay, so when they come to you before explanation, I find that they're confused. That's just been my experience. I've talked with some clients, some consumers, let's not even call them clients, just consumers, and I've asked them certain questions. One, some of them are like, I heard something about that lawsuit, but I really don't know what it's about. I have others that say, yeah, I kind of get it, but who cares, because I still just want my house sold and I just want to buy a house, right? So you're going to need to have these answers ready to go. You don't want to be fumbling around for them, and you do not want to make stuff up. Right? Because if you've ever had a target on your head in this industry before, it's never been like it is right now. All right? People are going to be asking a lot of questions, and if they find out that what you've been telling them is not 100% true or not transparent, or just not the full truth, just know that you're opening up kind of a target. Now is the time to be 100% honest. And let's talk about why we need to do that. The MLS. Why do you think in the MLS there's an agent version printout and a client version printout? Because we never wanted to talk about what the commission offered to the buyer's agent was. This whole industry set us up to have a problem, right? So now there is no reason for an agent version and a client version printout from the MLS anymore, because there won't be an offer of compensation allowed on the MLS unless it is just a blanket concession offered by the seller that can be used any way that they want by the buyer, right? We cannot say, oh, that concession is for commission, all right? That's the buyer's choice as to how that any concession offered might be, how it might be used, all right? Are you starting to understand how the industry set us up to be in this position, right? And many of us don't question it. And here we are. Okay? So, where is that offer of compensation going to be made? If there is an offer of compensation by the seller. Anybody have an idea where that's going to be? What are you going to do as a listing firm if there's an offer of compensation? If your listing agreement currently says that it will be shown on the MLS, your listing agreement needs to be rewritten because it won't be. Where are you going to show an offer of compensation if you're a listing agent or a listing broker? Any ideas? Marketing? What kind? Social media. You can also have on your website, you can have, you know how we have all the IDX feeds? The IDX feed that comes in from the MLS can be in one area. Another area on your website can say our listings, and you can have your offer of compensation for your listings in that area. Okay? It just cannot come from any data put together by the MLS. Now, tonight, I am having what I call a bourbon Zoom because I like to drink bourbon, and I'm having a Zoom meeting with the vice president of Showing Time. All right, he's a buddy of mine. I'm going to ask him what, if any, decisions they have heard, because I know some ideas are to put the offer of compensation in the showing instructions as an attachment, etc. I have heard that won't be allowed because that is technically data coming from the MLS. So I would suggest for the time being, don't do that. Okay? But I'm going to talk to my buddy. I was hoped to talk to him last night, but he was busy. So tonight I'm going to get on the Zoom with him and have a drink and find out what he knows. Okay? He also was the vice president prior. He was the vice president of the California Regional MLS, which is the largest MLS in the country. So this guy knows everything there is to know about that end of the business. So hopefully I'll have some more answers. All right. So the conclusion of this part of the agency relationship stuff is that definitions are important. How many of you, some of you in the room have taken the mandatory class with me? Anybody take the mandatory with me? We talked a lot about how words matter in that course. Definitions and words matter, and they're going to matter a lot for you, right? The word shall and may. You need to make sure that your agreements are written with shall or may in the appropriate places. Because if it says that the buyer may pay your compensation, that means they don't have to. It needs to say shall pay, right? How many of you are nervous about asking for compensation from the buyer? It's okay, raise your hand, high, low, whatever. Yeah, nervous? I tell you, when this first came out, I knew of agents that just jumped up and down and stomped their feet. I'm never asking my client to sign a buyer's agency agreement. That's ridiculous. Well, okay, you can think that, right? I love a buyer's agency agreement because it's going to explain a lot more of what I'm going to do and what I'm not going to do, and definitions are important. And if nothing is written out and agreed upon, just ask Mrs. Attorney over here. If it's not written out to be agreed upon, does it really exist? Huh? Can't enforce them. Some people have asked if I've ever had to enforce a buyer's agency agreement. Yes, I have. I have enforced buyer's rep agreements twice in 26 years. That's how many times I've had any problem with it. Both times, those clients went to their attorneys, and the attorneys have said, get your checkbook. All right? So enforcement of a buyer's agency agreement really comes down to a business practice. Do you want that press? Do you want that word in the community? I would venture to say in some cases, yes. Because I don't want people to think that I'm a pushover. My agents that work for me, if they're getting stiffed on a buyer's agency agreement, do you think my agents are going to want me to enforce that buyer's rep agreement? Yes. One thing that my agents tell me is that they always know that I've got their back. And that's one I always do, unless they're wrong. If they're wrong, I got their back in owning it, okay? But when it comes to those kinds of things, how this is done, how it establishes the common understanding and avoid misunderstandings is going to be highly, highly important. When you get paid, how you get paid is going to be extremely important. All right. All right. Listing agents have a listing agreement or a marketing agreement when working with sellers that outline an offering price, right? You have to have that. You have a duration of the agreement. There cannot be any kind of agreement with somebody without a beginning and an end. Listing agreement also speaks about compensation. As a listing agent, you have zero problem asking for X%. Right? Zero problem. How many of you have a problem asking for compensation as a listing agent? None. Right? Why? Mostly because we're actually providing tangibles. It's the intangibles that get hard to assign value to. And the intangibles are a lot of what a buyer's agent does, right? There's some tangible things, all right? But the quality of the service is not, oh, I'm going to hire the best photographer. Buyer's agents don't do that. Oh, I'm going to get drone footage. Buyer's agents don't do that, right? So it gets harder when you have to sell. Who are you selling? You. And I'm also going to tell you, we kind of get into, is Dom still here? No? I also used to work as a leadership transformation facilitator for a large leadership firm in Green Bay. And one of the things that we talked about there is the fact that I believe it's 70 or 80%, I got to go back and look at the numbers, 70 or 80% of our thoughts are subconscious. And out of that 70 or 80% of our thoughts, 90% of those are negative. So when we have the majority of our thoughts coming from, as Larry Kendall calls it, the non-conscious, and the majority of those are negative, that's where we start having the problem asking for compensation, because we have a hard time believing in ourselves. So learning how to believe in yourself and understanding truly what your worth is, then you're going to have an easier time asking for that compensation. So let's go back to the conversation I started, and I got sidetracked, squirrel, on my last job. They asked me what my offer of compensation was, or what I wanted to be paid, and I kind of chuckled and I looked at both of them. And I said, well, that's interesting that you would ask, because there's two different ways to look at what somebody should be paid. One is what the job is worth, all right? That person that hires you is going to say, this job is only worth this. What do you really do? What are you providing me, right? And then the other part of what you should be compensated is your knowledge, skills, experience, talent, and wisdom. How do you portray that? How do you communicate that? And a lot of people in talking about this buyer's agency stuff now, they're 100% correct. We need to be able to articulate our value proposition, but not just in the stuff. We're very good at saying, look at me, look at my company. We do all of these things out of pocket, and we pay for all this marketing. Wow. So what? What's your knowledge, skill, wisdom, and talent? Right? There's going to be people that have less than 5 years in this business that have more talent in certain aspects of this business, but may not have as much knowledge. How many of you have ever heard knowledge is power? Wrong answer. The positive application of knowledge is power. All right? So when you have this knowledge and you've got your skills and your talents as a buyer's agent, you've got to become good at positive application of that, because your application of your showing what your worth is more vital than all of the little things that you're going to do. You know that list of 179 things that NAR gives you? Who cares? All right? If we all hand out, oh, and they have another one that says another 105 things that, and guess what? That more talks about the buyer's agency, because NAR gave us 179 things that typically represented what the listing agent does. They never gave anything about what the buyer's agent does until now. See how we've been set up? Now they have 105 other things that more focus on the buyer's agency. If we all hand out that 179 thing list and that 105 list to our customers, our clients, and say, look at everything I do, what's the difference between you and me? None. So, as we drive through this, you've got to come to grips with who you are, your knowledge, skills, and wisdom, and how are you going to show that before they even hire you. And after your agreement is over with. How are you going to show that value to them? Because a lot of them see us get thousands of dollars for helping them to buy and sell a house, which I duly say many of us earn. There's a few that don't. But then we do this to ourselves. We post on Facebook, I've closed millions of dollars worth of transactions. And guess what they think? They think you've made millions of dollars. I'm a broker? That means I'm broker than the rest of you? I'm not making millions of dollars on that, okay? We have to show value before we show up, while we're there, and after we're done with that transaction. This is going to be more vital than ever for you to survive in this business, okay? All right, let's get back to the business. I get off on these things because I am really excited about the opportunities that we have. This is not a bad thing for us. This is a great, yeah, Sabrina's like, can you say that again? This is not a bad thing for us. It really isn't. This is a very good thing. It's going to raise the bar of professionalism. Some people will not survive. Good. When I teach my real estate classes, I usually say something like, you can teach real estate to a monkey. You can. But the decision-making process that goes behind actually helping a client professionally, those types of things, morals and values and skills and those kinds of things, a lot of those are learned, especially the decision-making process is learned in kindergarten, guys. I take a lot of agents that may not have the skills and talent that some think that they should have, but they've got the decision-making skills. I can teach them the technical things. Keith, you've done a lot of recruiting. Do you agree? Yeah. Raise your hand, Keith. Keith Rye's a local celebrity. Everybody give Keith a hand. Woo! That's funny. All right. So we have this listing agreement that has all of these things. Terms of the sale, authorization to place a sign, authorization to advertise, authorization for MLS entry, etc. How many of you build the same level of detail into your agreement with a buyer? There needs to be the same level of detail in an agreement with a buyer. I'm here to challenge the fact that a one-page buyer's agency agreement ultimately is going to do the job for you. It might, but you're going to have a lot of other information in your buyer consultation. Personally, I've got about a 6-page buyer agency agreement, and the reason I have that is there's a lot of things in there that are important to the client that I want documented. And I saw some heads shaking already. That's too much. Nobody's going to ever sign that. You know why? Because you think that. If you think that's going to happen, that's exactly what's going to happen. I actually saw a post on Facebook the other day that said, as a buyer, if I was a buyer, I would never sign a buyer's agency agreement. That came from an agent. Does that agent believe in what they do? No. 100% I can tell you no. If you believe in what you do, you want to educate that client, and you want to document that you've educated that client, and you want to show value along the way. What's wrong with documenting that education? Also, if your buyer's agency agreement is 1 page, what's the one topic of that agreement? Compensation. What's the only topic of conversation you can have with that individual when you pull out that piece of paper? Payment. You better be doing a lot of conversation otherwise about value, what you're doing for them, things they need to consider when purchasing a home. Now, it doesn't have to be in the buyer's agency agreement. Don't get me wrong. That's just my preference, right? Because I want to talk about those things and have it documented that I've talked to them about those, right? So you need to have a lot of different things in your buyer's consultation that actually provide and communicate that value of things and who you are and what you represent to them. All right? We just had a potential client call one of our agents and crying because they had been trying to buy a home on their own with no agent representation and was getting nowhere. And they finally said, I think I need an agent. Really? I felt bad for that person to be crying because we as an industry have made it so difficult for that person that they feel they have to get an agent? What happened to that person? I have no idea. I've also had in my past somebody call when they were trying to do a for sale by owner. They called me to list their house. She was crying because of all the phone calls and harassment that she was getting from agents, telling her how little she knew about selling her own home and how she was going to fail miserably and they needed an agent. Is that what we want? No. That's why we have to lead with our values, showing what we're going to do, how we're going to do it, before we even get to signing that document. Right? So that document is not something you lead with. All right. Here's another part of the LREC rules and regs. A licensee shall perform the terms of the brokerage agreement between a broker and the client. Okay, if you've never used a buyer's agency agreement before, how do you know what you're supposed to be performing and what you're not? That might be why some people don't like a buyer's agency agreement, because there might be a little more accountability. I like the accountability. I like for people to know what I'm going to do and what I'm not going to do. The listing agreement specifies that. I've had people call me up and say, hey, how come you weren't mowing my lawn? They're out-of-state seller, because my listing agreement doesn't say I'm mowing your lawn. I had a property in Colorado once. It froze up. The pipes all froze during the winter because her utility bills weren't paid. She was out of state. She called me up furious. How come you let my utilities get turned off? Well, that's not in the listing agreement. I'm not paying your utilities for you. Right? So do you want that unknown idea of what you will and won't do to be roaming around in that buyer's head? I don't. Okay? Do the buyers have a proper understanding of what you will and won't do? Do the buyers have a proper understanding of how you get compensated, or how much, or when? No, they do not. Ever. How many of you, I know you don't have to raise your hand, but how many of you have looked at an offer of compensation on a property and said, I don't want to show that house because it's not enough for me? It's gone through your head. Come on. Sure. All right. Do we have any commercial practitioners in here besides Elizabeth? Elizabeth, raise your hand. She's our CCM heading up our commercial division. Any other commercial practitioners? The commercial people are laughing their butts off at us resis, as they call us. And if you dabble in commercial, you're a resi-mercial. Just so you know that. All right? The commercial people are laughing at us resis because we think this is so horrible that we have to establish our compensation. Commercial agents have been doing this forever. Why do you think they have a different MLS? Because they don't offer compensation on it. Whoa! Well, why would you even go there if they're not offering compensation? Go get your own. All right? Do they understanding of how you're going to get compensated, or for how much and when? Depending, if you look at your listing agreement, Many listing agreements that I've seen, because every company kind of has their own, although there's some, commonalities to them, it says you've earned your compensation once a binding contract to purchase has been signed. But you get paid at closing. So that means technically you should be paid your compensation because that contract was signed, but only if one party or the other defaults, right? If the buyer walks away or the seller walks away and they do not terminate for cause, then you should be paid your compensation. How many times has that ever happened when somebody walks and doesn't go to closing? You should be paid. Same thing with a buyer's agency agreement. A good buyer's agency agreement should say that it is earned upon a ratified contract to purchase, payable at closing. If your buyer walks away from that transaction without due cause, should you still get paid? Yes. Yes. What'd you do? You did your job, right? Okay. All right, so here's some other things to think about. Might these things be important to have discussed and have written documentation of such discussion? I believe yes, and that's why my agreement's a little longer. I want written documentation of what I've covered with them. I tell this story every time I teach a class, so those of you who have had a class with me, just close your ears for a second. In my career of 26 years, I have had 5 real estate commission complaints, 1 association grievance, and 1 fair housing violation filed against me. I have never been found guilty of any of those. Do you know why? Documentation. Some people think I'm over the top, but I'm good at what I do. Dom talked about your algorithm and your processes. The agents that work for me can tell you that I have processes. Agents don't like processes. How many of you like processes? No, you don't. That's why you're good at selling real estate. You just might stink at paperwork. All right? But you got to have processes. That also keeps you out of trouble. What if you end up in a dispute later with your client about what you were going to do and for how much money? You want that spelled out. I want it in writing. What if the client buys a home using another agent? That's a caveat within a buyer's agency agreement, right? There should be a holdover period in your buyer's agency agreement, just like there's a holdover in your listing agreement. But it shouldn't, in my opinion, apply if they have signed a buyer's agency agreement with somebody else after yours is terminated. Because if you didn't do your job and they found that you weren't working well with them and they have to go hire another agent, are you actually due another commission? I don't know. That's up to you to decide. That's a business. Yes?
Do your buyer's agents allow them to fire you?
Yes. Yes, an agency agreement, honestly, and I've got that in what we'll cover in the last half of this class, is rights to cancel. Guess who came out with a showing property agreement yesterday? Zillow. Zillow. If you have never thought that Zillow was going to be in the real estate business, again, we created this problem because we thought, oh, look at this. They're going to send me leads. They are a brokerage. They own Dotloop. They own Showing Time. And now they're offering a showing property agreement.
What does that mean exactly?
It means that their next step will be buyer's agency. It means that they have the agreement to be able to show property for people that does not contain compensation. So they just have an agreement just to go show property. That's their way to start drawing people in. Eventually they will go to a buyer's agency compensation agreement. I can almost guarantee you. Who's your competition now, guys? All right. What if a buyer walks into a new home development and buys a home with the builder rep? All these things need to be talked about. Now, as you can see on the screen and in your book, I wrote this course in August of 2022. I only got to teach this class once in 2022 because nobody cared. This doesn't matter. I don't want to talk about buyer's agency. Do you know why I wrote this in 2022? Because I knew this was coming, guys. There's a lot of things that we've tried to educate on, and agents are very good at putting their heads in the sand and only doing things when they're told to. Because a lot of times nothing matters until somebody makes it matter. You got to be thinking further ahead than that if you're going to survive this industry. You've got to be thinking ahead. I don't care if you're a broker or as an agent, you've got to put your 30,000 foot view goggles on and be thinking about what's going to be happening down the road and be preparing for that, right? So what's the first thing that you should be doing? Anybody? What's that? You should be determining your value. You should be writing down things for yourself about your knowledge, skills, wisdom, and talent, and explain them to yourself that you can actually do this. If you don't know what your knowledge, skill, wisdom, and talent are, please ask somebody that knows you. They will be happy to tell you how great you are. If they tell you that you're a loser, lose them. Okay? Because there's talent, wisdom, knowledge, and skill with everybody that's in this room. And you've got to make a list of that, and you've got to be looking at it and believe in it. Okay? So I wrote this back in August of 2022. 2023, I taught it a little bit at the beginning, and then that's all I could teach at the end of 2023. Right now, this is the only reason I'm standing here teaching this is because I had agreed to do it before some other things had occurred. This will be the last time I teach buyer's agency for a while. The reason being, one, that camera makes me very nervous that I'm being recorded. It's too, litigation is too prominent right now. And I'm not an attorney. I'm telling you what is LREC law, and I'm giving an opinion, okay? But I'm not going to be teaching this again for a while until we see some more things shake out. Okay? What time are we at? 10:42. We got another hour. I'm going to burn through some of this. All right. So when you're representing a buyer and you don't really know what to do with that agreement, if you don't know how to handle the buyer's agency compensation, communication, or the presentation of that buyer's rep agreement, what do? You fake it till you make it? I wouldn't do that. Not at all. Brokers. How much do you actually know about what's going on? How many conversations have you had with legal counsel? How many webinars have you been on? How many reports have you read? That's practically all I do right now is read things, digest all of this information, and try to figure out what's going to be the best way for me to serve our consumers. So brokers, you're going to need to dig in a little bit deeper too. I want to get to the next piece. Let's see. How many of you like dual agency? Why? Because you make more money. Why do you like dual agency back there?
I find the hardest part of doing a transaction is dealing with the other agent on the other side if they're very experienced.
So you don't argue with yourself?
No, I explain it to my clients differently.
Yeah, okay. Dual agency, only in my opinion, this is only my opinion, should be outlawed. All right? Does that mean that you can't make more money? No. It doesn't mean you can't make more money. You still have many opportunities. And those of you who really understand and really latch on to what's happening and really create a good plan going forward have the opportunity to make more money than you've made. The consumers are going to come to you and say, I hear that your commission is now negotiable. Well, it's always been negotiable. We don't talk about it. How many times do you show up with a listing agreement already filled out with a certain percentage on there? That's bad practice. That'll get you sued. 100%. You need to have some kind of conversation about that before you present them with an agreement that has compensation in there. If you don't think that I'm telling you the truth, you should go back and listen to some of the testimony in the NAR DOJ settlement hearings. How many of you paid any attention to any of the testimony? It was horrendous. Horrendous. I think one of the worst ones was actually the CEO of Berkshire Hathaway, Gino Blafari. I know this guy personally. I've been on bike rides with him and the whole thing. But he actually was on video saying some things that just were not cool. You know? He's very well appreciated in that industry though. But words are going to matter, and how you approach things are going to matter even more. The level of professionalism, we all think we're professional, but how many of you have actually worked in a corporate environment? A corporate environment will teach you a lot of things. All right, when I went to work for Initiative 1 in Green Bay, Wisconsin, those people are the ultimate in professionals, and it made me uncomfortable, and I believe I'm a professional. It raised my game even higher working for them. The amount of expectation, most agents don't like expectation. How many of you write a business plan with an income goal every year? Some of you. Many do not because they don't like the expectation. Okay? We have expectations now. They're watching us. All right. We're not going to take a break. We're going to keep blowing through this. You can use the restroom if you need to. I do see some people using their computers and stuff. Please turn those off, put them down. I really am kind of serious about that. I really don't need anybody from LREC coming in here and giving me a hard time that I'm not enforcing that. Be respectful of me and my license. I'd like to be respectful of you and yours. Establishing agency is easy. Understanding agency can be tricky, and dual agency can sneak up on you. When those people walk into your open house and they're talking to you and you're the listing agent, those things can sneak up on you. So I want you to be the ultimate pro, have those disclosures, right? I want you to understand that right now, before you start instituting the buyer's rep agreements, establishing agency is very simple, and it's just as simple to terminate it. How many of you are starting to use buyer's agency agreements already before the necessity? Just a couple of you? Let me ask, and this is not a gotcha, this is not pointing something out. I want to know why you're not using them currently. I have a thought. Somebody want to tell me why you're not using one yet? What?
She said because I'm lazy.
Lazy? Okay, I'm going to venture to say it's lack of confidence. Okay, and that's not a negative, guys. That's not a negative. Confidence comes with the education and practice. Do not practice this stuff on your client. Do you know how many times agents practice on their clients? Horrifies me. Because they're scared of role playing and stuff. Don't practice on a client. Sit down with another agent. Sit down with your broker, somebody, and practice what you're going to say. If you're a ninja, there's things already that you're practicing that you should be saying during those consultations. We all should be. Another person that you should listen to if you have not gone through a ninja training is Brian Buffini. How many of you have heard of Brian Buffini? All right. How many of you have been through a Brian Buffini training? All right. I suggest highly that you continue to educate yourself faster than the guy sitting next to you. All right? Find some place that you can get good education about how to apply these principles that we're going to start talking about in the best practices of a buyer's agency agreement. Because you do not want to be stuttering in front of your clients. And you do want to have the conversations. Because if they find out later something that they heard that you didn't have that conversation with them, that target on your forehead just got a little bit bigger. They know we have insurance. All right? They also, because of all the posts that you make, think you're a bazillionaire. How many of you are bazillionaires? All right, a couple of you. Sweet. You can pay for my legal counsel. All right, navigating buyer's agency and best practice. Here's what you guys really came for, is wanting to know what to do with it, right? I gave you some homework. First is you need to write a list of yourself, what your talents are, your talents, skills, wisdom, etc. You've got to be very firm in who you are and have confidence. The guy that you see up here talking about all of this with great confidence is not the guy that I was 20 years ago. All right, there's a lot of work that goes on in here. I've had the exact same coach. I have a coach. I am a coach. I coach agents around the country. But my coach helps me maintain that level of confidence and focus. Jared has a coach. I don't think Jared has a confidence problem, but a focus problem. Jared, do you have a focus problem? Yes, he does. Agents, good agents, very typically have a focus problem. Do you know why? Because of your personality profile. Very high I, very high S. You're going to be all over the place. And that's great because you can be a very good agent, but you're going to have to work on some of the other things, right? Any of you DISC personality profile people? All right. If you want to know more about DISC profile, I'm also a DISC profile consultant. We can get you through one. Help you understand a little bit more about yourself and how you act and why you act, okay? Get it very clear in your mind what value you bring to the table and be ready to articulate it in the representation agreement you utilize. Now, I say representation agreement there, but honestly, it should say in your actions. It should say in your consultation, not just in your agreement, all right? Anybody ever read the book The Go-Giver? All right. The Go-Giver is an excellent read in how to think about the value that you provide, not just in gifts. How many of you do pop buys? Yeah, Lori, can you say Popeyes? Pop buys? Popeyes. Pop buys are little gifts that you give to your clients. You randomly drop off. They should be something of value to them. All right. Sometimes they're fun. Those kinds of things. You've got to be very clear about the value that you're going to bring before, during, and after this. And that gift that you're giving, the most valuable gift you can give somebody is what? Your time and attention. We're always on to the next. Do you know how many agents I see always on to the next? Always on to the next. They're always looking at their phone. They're always doing something else other than what's right in front of them. I loved it when Dom got everybody centered, and he's going to do it again after lunch. And that's highly important because agents by normal personality profiles are easily distractible. All right? Be present, give of yourself. Remember that you control the process and the client controls the decisions. How many of you have ever had kids? Kids. They test you. They continue to test you. I'm 57. Call my mom. She'll tell you. What kids are looking for, what we all look for, is safety, right? We want to know where the boundaries are. Where are we safe? Your client wants to know where the boundaries are in the transaction so that they're safe. Control that process. If they control the process and you're chasing them, guess what you're going to do the entire time that you're in a transaction with them? You're going to chase them. Part of this is being handled for you. How many of you, when you got a phone call, if somebody wanted to see a house, would race out and show them the house? They're controlling the process. You're chasing them. Controlling the process now will mean that these people, before you show them a house, have to have some kind of written agreement with you. That process should entail a very professional buyer consultation. Where should that buyer consultation take place? At the office? A coffee shop. In today's society, a coffee shop is considered a professional business place. All right? Fair enough. All right? Shouldn't be happening at the home that you're showing them. That's too late. It shouldn't be happening on the hood of your car. Okay? It could happen at their house, their apartment, wherever they are currently domiciled. I love the word domicile. Anybody ever watch Breaking Bad? And he's in that camper, he goes, "This is my domicile." He says more, but I love domicile. So the point is having a good professional conversation with them. How many of you have a buyer's guide? What's in that buyer's guide? Does it talk about your company? Does it provide education and guidance about the process in that buyer's guide? Do you know how many buyer's guides and seller's guides I see around the country, and they're one thing? They're a drag and brag. Have you noticed that I don't say presentation, I say consultation? You should never be making a presentation. A presentation is a one-way communication. All right? Change your words. Words matter. How many of you have past clients? Change your words. You have established clients. The way we think and the way we're taught in this business is so backwards from professionalism. Do you think that a doctor says you are a past client, a past patient? No, you're an established patient. You say, "Are you taking new patients? I would like to come and get established with you in your office." That's normal terminology. We don't say that. We're establishing a relationship with an established client that's going to receive value from us before, during, and after the sale. All right. Control that process. Don't go chasing after them. Have you promised the same value to the seller in getting the best price and terms? And if so, can you do the same for the buyer when acting as a dual agent? Nope. That's why I don't like dual agency, because you go in on this listing presentation, you say, "I'm great. I'm the greatest listing agent ever. I'm going to get you the best price in the shortest amount of time, and this is everything I'm going to do for you. And oh, by the way, this buyer is coming over here, so now I'm going to be a dual agent." I think they should renegotiate your commission right then and there, because they're not getting what they hired you for. Be very clear in your mind how you talk and work with your clients in the direction you're going to take, especially going forward. Dual agency is really going to create some issues with the way this is going now, because if you now have to have a buyer's agency agreement with a buyer and you have a listing agreement, you're automatically either going to need to have a dual agency disclosure signed with both of those up front, and then have both parties sign, once you enter into that, to remind them that's what you're doing. Might your client expect a different compensation rate? I have an answer for you of how to work this. But I want you to really think long and hard about how this is going to go, guys. All right, here's my disclaimer. I'm not an attorney. We're going to talk about some language samples and some things to do. Before we do get into language samples of a potential buyer's agency agreement and things to communicate to a buyer, let's talk about how you can avoid the dual agency problem with an unrepresented buyer. What if a buyer comes to you and they don't want to be represented? They say, I'm going to save that commission and offer less on the house. Okay. The seller thinks, well, if I'm not paying a buyer's agent, I'm going to keep the extra because I'm not paying for one. This is actually a very good conversation to have with somebody about offering compensation and having a buyer's agency agreement. Because the money that is used to transact a real estate sale is still going to be the same money that's used to transact a real estate sale. Who pays the agents right now? Who pays the agents at closing? You're all right. It's both. It's both. But here's what the industry did. Okay, the industry has put all the compensation in the listing agreement that the seller signs, and then the closing disclosure that has been given to the closing people all have that compensation coming from the seller's proceeds. So on paper, it 100% looks like the seller is paying for all of this. Does the seller have money to pay anybody if the buyer doesn't bring any? Usually not. They might, but usually not. So the money that's actually used to compensate and pay all the fees, whether it be title attorney, whether it be a lender, whatnot, that all comes from the lump of money that's coming at the transaction. Both parties are paying. Okay? That's a good conversation to have with them because, hey, I'm selling my house. I'm not going to offer compensation. But I want a buyer's agent to represent me on the house that I'm buying. Well, you need to help the consumers understand how it's been done and ask what they really want. Because if they're going to be buying another home, they want that seller to probably work with them in a reasonable fashion. And so why would they not work with the agent that brings a buyer in a reasonable fashion? And what's reasonable? That's up to them, right? You guys get to determine how much you're going to get paid. And the seller may cover some of that, may cover all of it, may cover none of it. Okay? So let's talk about how these agreements are going to go. One way to do this, let's go back to the customer piece, compensation. So let's say that you're a seller's agent and a non-represented buyer shows up. They don't want any representation. You did an outstanding job of a listing presentation. And you are an outstanding seller's agent. But this buyer came. They don't want to use a buyer's agent. They want you to do it. You can use a customer agreement. A customer agreement sets that up very clearly that you are a seller's agent. You are not representing them. You will not be assisting them. You will do nothing. And according to that agency disclosure, technically, the way I read it, is that you should not be filling out that document for them, even as directed. You can go, here's the contract, Mr. Buyer. You don't want an agent? Have at it. But most times that agreement is not going to be filled out correctly. And most times there are going to be amendments that need to be done. And most times there are going to be inspection resolutions that need to be done. Who's going to do that? The listing agent. Somehow, you're going to be helping with that process, right? They should be filling out the documents, but you're still going to have to do some things along the way with them. Who's going to be at that inspection for the unrepresented buyer? You're going to let the unrepresented buyer sit around in the seller's house by themselves during the inspection? Nope. Listing agent, probably going to be at that inspection. So I challenge you to think that if you're a listing agent and your compensation is X, but if an unrepresented buyer comes along and I treat them as a customer, my compensation might be Y. Because I'm going to be doing more to protect you, Mr. and Mrs. Seller. Does that make sense? Sometimes in the past, we've done variable rate commissions. Variable rate commission is not a 3/2 that you see on the MLS. That's a misnomer. That's a tiered commission. A variable rate commission is one in which you have an agreed upon amount with the seller. Unless you bring the successful buyer, then possibly it would be lower because there was no other agent involved. This is reverse, right? If there's no other agent involved, I've got more work to do. So I go this way. Think about that, guys. Do you think you're going to earn it? Another thing that was said on the Adorna Carroll webinar, somebody made a comment in the chat. It said, I don't want to have to use buyer's agency agreements because I don't want to be in my buyer's way of getting the home that they want. If you think you are in your buyer's way, you are. That was the exact response I gave in the chat. And Adorna said she's going to use that. Yay, I'm going to be famous through Adorna. If you think you are in your client's way, you are. Change your thinking. That's why people that are saying on social media, if I was a buyer, I would never sign one. They think they're in the way. That's why they wouldn't think of signing one. You have to show some value. So the value you bring has to be very evident before you have a topic of compensation. So, in your buyer's rep agreement, what should be included? What permissions do you need from the buyers? What disclosures should you make to the buyers? These are all things that are included in the listing agreement. We have a lot of permissions granted to us in the listing agreement. Without a buyer's agreement, we don't have any permissions granted to us in writing. Okay? What should be in there? Who are the parties to the agreement? Sometimes you end up working with one part of the couple or the family and not so much the other part. You need both signatures on this agreement. All right? A buyer's rep agreement is not community property. All right? So you need to make sure that you actually understand who the buyers are. So let's talk about somebody who says, oh, I'm looking at this house for my sister. And if I like it, then she's going to fly in and take a look at it. Should you have a buyer's agreement with that sister? Is she the buyer? You might have some kind of agreement with that sister. A showing agreement of some kind that may not talk about compensation because is that person really your buyer? But you still have to have an agreement in writing, right? NAR is very clear about that in the announcement they gave yesterday. The agreement you have does not have to be a buyer's agency agreement dictating compensation. Most circumstances it will. Some circumstances it won't. So the buyer is the sister. So the sister flies in and she wants to see the house. Now what do? Buyer's agency agreement. What if the sister has a significant other who's out of state? They need to sign it. Okay? Because that's how you're going to actually have authorization and compensation. So here's some sample language. I think it's a little wordy because it defines what acquisition or ownership interest of a property is. It says buy, purchase, or acquire means to buy, purchase, acquire, lease, or rent. Because this agreement is also for a tenant representation, okay? So they might say, well, I didn't buy the property. I didn't acquire the property. I'm only using the property. This has a little bit more delineation on what you're going to get paid for them doing, right? Purchase or acquisition means purchase, acquisition, lease, or rental. Seller means seller or landlord, gross purchase or sales price. So that's the other thing, guys. In your compensation, whether you're a listing agent or a buyer's agent, is your compensation based on the gross sales price or the net sales price after seller concessions? Should you be compensated with commission on a seller concession for closing costs? That's a business decision, guys, right? Sometimes I think it's more fair to the client to say, well, my compensation is going to be on the net because they're using that concession to pay for closing costs, et cetera. Other times, all right, I think, yeah, I'm doing my job. That's sales price. I have not come to a clear thought in my head about it, but I want you to think about it too, right? All right. What else are you going to talk about, right, in this agreement? You're dealing with people's hopes and dreams. So I hope at some point in your buyer's consultation, you're actually getting to that and not just the DNA of a house. The DNA of a house is the square footage, the style, the beds and baths, etc. And it doesn't really talk about the lifestyle that they're wanting. If you want to project value, do you think you might want to dive into the lifestyle that they're wanting? Find out a little bit more about them? I would think so. So you're going to talk about the general market area, town, parish, neighborhood, distance from work, general description of the property, acceptable flood area, price range, type of loan that they might be using. You might want to counsel them on what type of loan might be good in conjunction with their lender, because here's what you're going to do. You're going to give referrals to these people, to 3 lenders, and the lenders are like, no, just one, just me. Be good at your referrals because you don't ever want to be tagged with a faulty referral either, right? Give them choices. Let them decide, right? We control the process. They get to control the decisions. That person's going to choose a lender based on a couple of things. 1, how they interact with them, and 2, maybe on fees and rates, okay? Then you are going to be connecting whatever type of loan they have to a specific property. So you're connecting a person to a lender and then the loan to a property. Explain that to them. Because if they come at you with a VA or an FHA loan, you're going to possibly be looking at different properties than you would for a conventional, right? Because there's going to be some different conditions. Speaking of lending, Fannie Freddie have announced that any amount paid for compensation to the agents that is customary and normal will not count against any concession for down payment or closing costs, okay? So a Fannie Mae loan, they can concede between 2 and 9%, depending on the terms of that loan, to be used as a seller concession for that buyer. If they're also paying a concession or an amount for your compensation, it is not included in that 2 to 9% that Fannie Mae is allowing. VA and FHA, VA is going to be the problem right now. Because we haven't gotten any clarification from VA, have we, Fallon? No. Also, the buyer's agency agreement creates an agreement of the goal. What is their goal? Have you ever had a buyer get sideways on you? And they start looking all over the place, and they start looking at other things and doing different stuff. You have to take them back to their goal, and this agreement gives you that ability to do that. There's a beginning and the end. When did your agency relationship actually begin? It now begins when you have that signed, right? When does it end? When it's over, and there will be an end date in there. So here's some sample language for the term of the agreement, all right? Pretty simple. What are the obligations of each party? How are negotiations handled? Is there a discount for the buyer finding the home themselves? Is there a discount for the buyer finding the home themselves? No. They would like to think that. How many times do you hear, I found the house, you didn't even find it for me? I hear that talked about all the time. My agent didn't even find the house. I don't even know what they do. Finding the house is the least of our concerns these days, right? Because all that went out the window when IDX feeds went to Zillow and whatnot that we decided was a good idea, right? Your agreement needs to state whether there's a discount for them finding the house or not. Mine says there isn't. Okay, broker's obligations. Here's where you start to outline what your obligations are as the designated agent. Broker shall use diligence in locating the property, represent and assist the buyer in negotiating the purchase or acquisition of the property, use the broker's best efforts to procure the purchase or acquisition of the property at terms acceptable to the buyer. Broker's duties, and here are the keys, guys, include loyalty, disclosure, confidentiality, due diligence, reasonable skill and care, and accounting subject to the terms restrictions. That's your fiduciary duties. You need to make it very clear to your clients that you are acting in a fiduciary capacity. And then explain what fiduciary capacity means at their direction for their best interests. Here's the buyer's obligations. How many times do the buyers really understand what their obligations to you are? Very few. Very few. They get excited. Their reticular activator comes on and they're looking at houses. They're looking at houses more than you are. That's how they find the house, because they're looking harder than you are. Buyer shall, during the term of this agreement, including any renewals or extensions, conduct all negotiations and efforts to locate the property through the broker only. Well, that means they can go look all they want. We can't stop them from doing that. And shall refer to broker all inquiries received from real estate brokers, salespeople, agents, prospective sellers, or any other source. That tells them right there, guys, hey, if another agent talks to you, you need to send them to me. Right? Simple. It's talked about. Buyer represents that buyer is not now a party to a buyer representation agreement or otherwise obligated to another broker for compensation. That's vital. How many times have you talked to a buyer and said, hey, do you have an agent? What do they say? No. You show them a house and then what? Oh yeah, my agent's going to write that up. That's going to eliminate this. Okay? Buyer represents that all information relating to the buyer's ability to purchase or acquire the property is true and correct. All right, what's this? Elephant in the room. What do you get paid? Don't say it. But you have an amount in your head that you should be paid. And I bet that amount came from the understanding that that might be an industry standard or customary. Right? That's what the consumer thinks too. The consumer now says, I don't have to pay a 6% commission. You've never had to pay a 6% commission, but many agents have led them to believe that. I sat down with a lady the other day. She said, yeah, I just listed my house for sale. I said, oh, great. I said, now I know you're not my client, but I wanted to ask you a few questions from a consumer's perspective so I can get some answers. I said, do you mind telling me how much you list, what compensation you agreed to in your listing agreement? She goes, yeah, 6%. I said, oh, okay. I said, do you know that's negotiable? She said, yeah, I know it's negotiable. But that's just what they had filled in the document before they sent it to me. Do you see where that's going to get you in trouble? It has to be conversation, guys. My fee is this, right? As a listing agent, my fee is this. Okay? Now, what might you want to offer to a buyer's agent, if anything? That's the next piece of that conversation, right? If anything. So who's going to pay you as a buyer's agent? Who's going to pay you? Who? The buyer? Okay? That's negotiable. There's going to be options. There should be options in your buyer's rep agreement as to how you get compensated. When are you paid? We talked about that, right? Usually at closing. I hope that this is gone now. Never say that buyer's agent services are free or don't cost the buyer anything. That's another reason that we got to where we got, is because many agents were saying that because that offer of compensation was being handed to us on the MLS. All right? And in fact, they didn't think their buyer was paying anything because it looks like on paper it's coming from the seller. And now Do you know what an MLS really is? An MLS is, until this point, has been an offer and contract of compensation. That's what that has been. Because if you are a subscriber to the MLS, that compensation offered is a contract between you and another subscriber of the MLS. Well, that compensation is not going to be there anymore. So what is the MLS going forward? It's a compilation of data. It's a compilation of data. It's a marketing platform where marketing begins. Marketing starts there and disseminated throughout the world via IDX. That's what they are. Okay? Compensation is no longer included in there. All right, so here's some options for you to establish your compensation. One, the buyer may compensate your brokerage directly in lieu of listing from the offer of compensation. So if there is an offer of compensation being given, the buyer can select to reject that offer of compensation and pay you directly. Where will this be stated? In the purchase agreement. How many of you believed up until this point your compensation should never go in the purchase agreement? Anybody ever hear that? Yeah, that's a misnomer. It's always been allowed in the purchase agreement. Your compensation has always been allowed in the purchase agreement, but you have had to have three things in order to do this. One, a written buyer's agency agreement. Because you cannot unilaterally include your compensation in a purchase contract between two other parties. The second thing you have to have is it has to be in the buyer's best interests for you to put it in the purchase contract. Just because your buyer's agency agreement might say, and it should say, that the buyer authorizes and directs you to seek compensation through the transaction from the seller, you also have to be directed by them. And it has to be in their best interest. Who determines their best interest? They do. Just because you have this buyer's agency agreement signed, it does not mean that that's going to always be in that buyer's best interest. They may say, no, don't put your offer of compensation in there. I want this house very badly. I don't want to mess up the deal. I will pay you your brokerage directly. Okay? They might say, yes, I can't afford to pay you directly. Put it in that offer of compensation and maybe offer a little bit more for the house. Or they may say, no, still offer them this below asking price and still to pay you. Who makes the decisions? The client. All right? All you have is the authorization. So those are the three things that you have to have. Written buyer's agency agreement, direction from the buyer, and it has to be in their best interest as determined by them. Okay. Another way is the buyer may compensate your brokerage in addition to the listing firm offer of compensation. So, what if the listing offer, the seller's offer of compensation is lower than what they're obligated for? And the seller doesn't want to compensate the difference. The buyer does. Okay? What if your agreement for... and your firm may take compensation only from the listing firm in the form of their offer. So let's say that their offer is Y% of compensation, and your buyer's agency agreement is for X, which is lower. Can you take that offer of more? No. You can only take what your agreement says. Now, also, we have heard much more clarification. Some brokers and agents were starting to head down the road of putting in a range of compensation in their buyer's agency agreement. I would not do that. Right now, the legal advice is not to be putting a range of compensation in there. They were assuming that if you had a range, that the most you could take is that lower amount unless the offer of compensation from the seller was the higher amount. I don't think you want to be the test case for that. I think you really need to determine your value, contact Mrs. Attorney and find out what her guidance may be on some of these things. But right now, the guidance that I'm hearing is not to use a range of compensation, to have a fixed amount. So should that fixed amount of compensation be a flat fee or should it be a percentage? Could it be either or? Right? You're going to see all kinds of different compensation structures. We already have different kinds of compensation structures. It's already been happening. There's different types of companies. There's agents that offer flat fee. There's agents that or brokerages that offer flat fee. Brokerages that offer menus of service. All kinds of different things. You need to figure out what your path is, what your brokerage path is, right? And then go for it. Okay? Your firm, let's see, yeah. So then your firm can agree to the minimum amount of compensation. If the co-op offer doesn't cover that amount, the buyer would make up the difference. That buyer can make up the difference however they want. Could you renegotiate it with your buyer? Let's say it's X and a half, and you have your buyer's agency agreement for Y, and the difference is only half a point. Might you amend that buyer's agency agreement to just take what is being agreed upon there? If you amend your buyer's agency agreement for that, amend it only for one property, that property. Do not do an overall amendment to your buyer's agency agreement, because at that point, you have now reduced your offer, your compensation for everything. Use that as a case-by-case tool to make things happen. How many times have you, I know there's something on the, and I think Jared texted me about this, about whether a refrigerator is included or not. And how many times have you bought things or paid money for things to make a deal happen, right? It's the same concept, right? If you're within a reasonable range between you and your broker and what you've decided that you should be charging as a buyer's agent, you can amend it for that one property if you want. All right, so here's an example. Purchase price $450, co-op offered. It will no longer be on the MLS. This was written in 2022. Didn't see that one coming. Buyer agreement is at 3 1/4. Listing firm pays this, buyer pays that. And technically, you are to disclose the additional compensation because you're being compensated by more than one party. Okay? Unless we hear other guidance otherwise, that's the way I understand that law, is that if you are compensated by more than one party, you have to disclose to all parties of that compensation. Okay? So here's an example of that language. Broker's compensation. Broker's compensation shall be paid as follows, with no discount or allowance for efforts made by the buyer or any other person. Brokerage firm is entitled to receive additional compensation, bonuses, incentives paid by the listing brokerage firm or seller. Guess what? That will not be allowed anymore. You cannot take bonuses or incentives. You cannot take anything that is more than what your agreement states. So if there's a listing agent incentive that would make your compensation higher than what your agreement is, you have to write that out of the deal or write that as some kind of credit to your buyer, which in my mind was a question all to begin with. If there was a listing agent offering a bonus or a seller offering a bonus for a contract and closing by such a date, my question has always been, should that agent be getting that money or should it be the client? That's always been my question. And sometimes that little bonus was always in the agent remarks, and we never printed the agent remarks for the client because we didn't want them to know we were getting a bonus. Why do we think that way? See how we brought this upon ourselves? How many of you believe in the value that you provide as a buyer's agent? Raise your hand, really high. Who believes in the value they bring as a buyer's agent? Great. Tell me what your value is. Tell me what your value proposition is. Market knowledge, negotiation skills. I heard negotiation skills first, and that means something. Market knowledge, what else? What? I couldn't hear it. Home's potential, thank you. I used to be I was a professional drummer, and I played in many, many rock and roll bands. I have, my hearing's going. Sorry. I will tell you that y'all raised your hands very quickly when it came to, yes, I have value as a buyer's agent. But there was dead silence for about 3 to 4 seconds before anybody said anything about what their value was. What that says to me is that we don't have our value proposition at the top of our mind when somebody asks us. We need to have that first and foremost. One of the first things that I heard was negotiation skills. Okay, possibly. All right. I have negotiated and closed over 1,000 transactions. There's agents that have done more, there's agents that have done less. Might I have more negotiation skill than an agent who's never negotiated? Maybe. All right? Here's the other thing. How many of your buyers have possibly been married and or divorced or had kids that won't eat their green beans or bought a car? They negotiate for themselves on a daily basis. Everybody can negotiate in one shape or form. Don't lean on negotiation skills as your leading value proposition. That's the least of your value. Your value comes from the other knowledge about neighborhoods. What has flooded? When did it flood? When did it not? When were those houses built? Especially, I mean, come on, we have lack of building permits, and we don't even know when half the houses around here were ever built. But some of these agents that have been around forever, like Keith, they know all that. I'll tell you somebody who does. Troy Rezan over in Slidell, he knows about whenever any neighborhood was built in Slidell. You call Troy and say, hey, Troy, when were these houses built? He says, well, I was about knee high to a beer can, and so that would have been about... I'm telling you, there's people that know that. Does Troy have a different set of value than you do? Yes. Okay? So there's some different language in here about the purchase compensation. Talk to your broker about whether you're going to be offering a flat fee for service. Maybe that flat fee for service is going to be between this price and this price. It's this much. If it's between this price and that price, it's this much. You might want to be careful about just offering a flat fee because they may 100% change the purchase price range that they're in. Sometimes they find out that $400,000 isn't going to get them what they want, and so they jump up to $600,000, but you may have your compensation set at this. If you're okay with that, that's fine. Because there's some people that ask, why is your compensation based on the value of the house as opposed to the value you're bringing? All right, you make a decision on that, right? I want to ask the same question to the class action lawsuit attorneys that they've accused us of. They've accused the real estate industry of collusion and fixing compensation so that we have artificially inflated the cost of homes. All right? If you go to one of their lawyer gatherings of class action lawsuit attorneys and ask them how much each one of them charge for a class action lawsuit, it may be a very slim difference in amount of what each one of those charges. Do you think they talk about it? Oh, well, I'm getting this. I bet they do. And why was their compensation tied to the billions of dollars that were now paid out supposedly to the consumers who are maybe going to be lucky to get $100, $200 out of this thing? Right? There's a lot of questions about what's been happening. Another thing, when you're a new agent What's the first thing that they say you should do? They say you should go work with a buyer. It's easier. They don't train you. They just say, oh, go do an open house. Maybe you'll pick up a buyer. That's what this industry has said is the value of a buyer's agent. That's what they've ingrained into our heads, is that a buyer's agent is less valuable than a listing agent. I disagree. I disagree. I think that a very valuable, highly skilled, well-educated, talented, knowledgeable buyer's agent can make or break that transaction just as much as a highly knowledgeable, experienced, talented, skilled listing agent. But we've never said that. We've always placed very little value on the buyer's agents. Place more value on what it is that you do. Write that value proposition about who you are. All right, so the bonuses, yes, if there's a bonus that still falls within your amount of compensation in your buyer's agreement, you need to disclose that that bonus is coming, and that's going to fulfill a part of that agreement that you have with the buyer, okay? So now comes, how are we going to do all this? We're down to the last few minutes. We don't know where we're going to find offers of compensation, if there are any yet, do we? Some people say, oh, well, we'll just call the listing agent. How many listing agents answer their phones? I had agents that would call me and they say, thank God you're the listing agent because I know you're going to answer your phone. And that was at a time, literally, people, I had between 100 and 110 listings at all times in my career. 100 and 110 active listings in my career, and I answered the phone. Don't tell me you're too busy. Don't even. All right? Answer your phones. We're going to have to communicate. Here's the other thing. We're called cooperating brokers. That term has kind of gone away. And for some reason, we're now in the business of out bitching each other to the closing table. We have to stop that. We have to communicate because we've got buyers that want to buy, sellers that want to sell. We have to figure out how this compensation is going to work if anybody's going to be successful to get to the closing table. Answer your phones, people. Well, if I don't recognize the number, I don't answer it. Get over it. Get over it. Answer the phone. If it's a spam call, hang up. Answer your phone. All right? That's my preaching for the day. Can I get an amen? All right. So, retainer fees. I've got just a couple more things I want to talk about. Can you charge a retainer fee? Yes, you always have been able to charge a retainer fee. I think we're going to see more of those. Agents at my firm used to charge anywhere from $300 to $500 retainer fee before they even put people in their car. Some of that's going to be market driven, some of it's going to be competition driven. Competition is a great thing. All right? Will that retainer fee be refundable to the client? Depends. That's the attorney's answer. Depends. Depends on how the agreement's written. Personally, my retainer fee would be credited to the buyer at time of sale against whatever they owe me. Right? But if they walk away and don't buy a house, have you at least gotten something for your gas time, your research time? Start thinking about that, guys. Think about what you're actually worth and start standing up for it. Have those interviews. Actually stand up like everybody else. Does an attorney charge you a retainer?
Nope, not a flat fee.
Flat fee. All right. Do doctors want payment at time of service? Yeah. All right. Okay. There's some retainer fee language in there. Protection period, we talked about that. Oh, here's another thing. How many of your buyers think that you work with just them? They do. And they should feel like that 100%. All right? Yes?
Our agents feel that way too.
Yeah. Arena says their agents feel that way too. That they only work with them. And that's honestly how your consumer should feel, right? That's called, as Dom said, being in the moment. I'm so glad he talks about that because we are so busy. Do you know how many people I see texting right now that I should say, you don't get CE credit because you've been violating the rules? Many. Pay attention to who's giving time to you. I don't do this. I can teach my own brokers. I can teach my own agents. I like to share the knowledge. Be respectful of the people around you that you're spending time with, your clients included. It's a respect thing, guys. You think you're important, but your client is important. Okay? They need to know that you're working with other people. There's also going to be, let's see, we're going to get past that. Oh, yeah, here you go. What if you want to fire them? If you don't have a written agreement, how do you fire your buyer? Do you ghost them? You can't ghost them because that's actually a violation of real estate practice law. That's called abandonment. They can file complaints against you for abandonment. You actually have to have that conversation and fire them. Can they fire you? What if you're no good? What if you're not listening to them? Can they fire you? Absolutely. They should do that. Grant, wasn't that you that asked if there was a termination? Yeah, there should be a termination in there. Because if you're not doing your job, they should be able to terminate you too. All right. I am going to stop right there. Are there any questions that you have at this point that I have not answered or maybe that I brought up that you've thought of? Yes?
You share your buyer form that you use?
Will I share my buyer form? No, I will not because I'm not an attorney and I cannot give forms out as legal advice that somebody else could use. A brokerage needs to have their own forms done. Yes, Reed?
Okay, so the stuff that says that you can't accept more compensation higher than the buyer deal, you said you renegotiate the buyer deal agreement. Is that after the fact? Like,
You could. So her question is, so, you can't accept more compensation than what your buyer's agency agreement says, but I also said that you can renegotiate it to accept less. Sure, you could technically renegotiate it to accept more, but how many buyers are really going to do that very often? Probably not, but yes. The technicality of it is yes. If both parties agree to it, yes. Okay, yes.
I mean, I started using the buyer's agency agreement, I haven't had a problem. My question is, you've used them for several years. Have you had buyers sign a buyer's agency agreement with an agent and then go and sign another one with some other agent?
Yes, so her question is, yes, I've been using buyer's agency agreements for 26 years, okay? I've always used them. And have I had a problem with a client signing one with me and then signing one with another? Yeah. I have. In those instances, I have not pursued them because that was a very good indicator of things not going well. And I always was of the fact, in fact, I tell my people this, hey, if this is not working and we're not agreeing and we're not being successful or, really getting to the goal that you want, I'll tear this thing up because I don't want to be in their way. And if I don't understand them and cannot communicate in their way, they need to find somebody else. No. All right. You guys have been a lot of fun. I hope you learned some things about best practices. Be sure that you sign out. If you did not sign in, you missed it. You won't get credit. But for those of you that did sign in, be sure that you sign out. Remember the page number that you had signed in on. It'll be easier to find. And I'll have certificates ready later. Thanks a lot.